Welcome to Law as Order E1 Full Faith and Credit Clause. Article 4. This agreement is valid for 3 years from signature and can be renewed or terminated by mutual agreement. In the event of termination, the parties shall make all reasonable efforts to provide a suitable transition period to facilitate the transfer of existing responsibilities. Article 5. This agreement may be modified at any time upon mutual agreement of the parties. Any modifications made thereto shall be in writing and signed by both parties. Article 6. This agreement shall be governed by and construed in accordance with the laws of the state, and all disputes arising out of or relating to this agreement shall be subject to the exclusive jurisdiction of the courts located therein. Article 7. The parties agree that any notices or other communications provided for in this agreement shall be in writing and shall be deemed to have been given. Upon delivery, if delivered personally; upon receipt, if sent by certified mail; return receipt requested; or if sent by facsimile or email, upon confirmation of receipt. Article 8. This agreement constitutes the entire agreement between the parties with respect to the subject matter hereof, and supersedes all prior and contemporaneous agreements and understandings, whether written or oral. No waiver of any of the provisions of this agreement shall be deemed, or shall constitute, a waiver of any other provision, whether or not similar, nor shall any waiver constitute a continuing waiver. No waiver shall be binding unless executed in writing by the party making the waiver. Article 9. The parties acknowledge and agree that this agreement is intended to be for the benefit of both parties. Neither party has the right, power, or authority to act or create any obligation on behalf of the other. Article 10. This agreement's remaining provisions will remain in force if any are invalid or unenforceable. Article 11. The parties accept this agreement's terms and conditions as legally binding. In witness whereof, the parties have executed this agreement as of the date first written above. Section 1 Full Faith and Credit Clause. The Full Faith and Credit Clause of the United States Constitution, found in Article 4, Section 1, reads, "All states shall give full faith and credit to each other's public acts, records, and judicial proceedings. And the Congress may by general laws prescribe the manner in which such acts, records and proceedings shall be proved, and the effect thereof." The Full Faith and Credit Clause allows the federal government to recognize state laws, legal proceedings, and records. It requires each state to recognize the laws, legal proceedings, and records of other states as they would their own. This means that a court in one state must recognize and enforce a judgment issued by a court of another state, even if the laws in the two states differ. It also means that a court in one state must accept as valid records and documents issued by a court or government agency in another state. The clause does not require states to grant each other's laws the same weight or deference as their own laws, but it does require that the laws of each state be respected. This principle applies to all states, including territories and the District of Columbia. The Full Faith and Credit Clause does not apply to private contracts between individuals or entities located in different states. These contracts are subject to the law of the state where the contract was signed or performed. However, a state may choose to recognize and enforce contracts from another state. In such cases, the two states may enter into an agreement to recognize and enforce each other's contracts. Overview of the Full Faith and Credit Clause. Article 4, Section 1. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. And the Congress may by general laws prescribe the manner in which such acts, records and proceedings shall be proved, and the effect thereof. The U.S. Constitution's Full Faith and Credit Clause requires each state to give the federal government full faith and credit. Full faith and credit to the public acts, records, and judicial proceedings of every other state. This means that state laws and court decisions must be respected and given the same legal effect in all other states. In addition, the clause gives Congress the power to create laws that prescribe how such acts, records, and proceedings should be proved, and what effect they will have. This clause aims to standardize state laws for a more unified government. The clause has been used in divorce, child custody, bankruptcy, and contract and judgment enforcement. Historical background on the Full Faith and Credit Clause. Article 4, Section 1. The Full Faith and Credit Clause is a clause in the United States Constitution. full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, it states. This clause was included in the Articles of Confederation and the original U.S. Constitution in 1787, which were the foundation of the United States government. This clause ensures that all states recognize and enforce laws and court judgments from one state. This clause is important because it allows for more efficient enforcement of the laws of the United States. It also reduces the chances of conflicts between states and encourages the free flow of commerce between states. The full faith and credit clause has been interpreted by the courts in various ways. In 1819, the Supreme Court established the principle that the full faith and credit clause was not meant to interfere with the power of a state to apply its own laws. In other words, states have the authority to set their own laws and courts have the authority to interpret them. The Supreme Court has also ruled that the full faith and credit clause does not require states to recognize laws or court judgments from other states if it is contrary to public policy or the state constitution. The full faith and credit clause protects individuals' rights across state lines and enforces laws in all states. In recent years, the Supreme Court has used the clause to protect the rights of same-sex couples, ruling that states must recognize same-sex marriages performed in other states. This decision has been hailed as a major victory for civil rights. Judicial proceedings. Article 6, Section 2 of the United States Constitution states that, judicial power shall extend to all cases, in law and equity, arising under this Constitution, the laws of the United States, and treaties made, or which shall be made, under their authority. This provision grants the federal court system jurisdiction over any cases, in law or equity, that arise from the Constitution, federal laws, and treaties. In the U.S., court proceedings begin with a complaint, petition, or suit. This document typically describes the facts of the dispute, identifies the parties involved, and outlines the relief sought by the filing party. Once the complaint, petition, or suit is filed, the other party, the defendant or respondent, has an opportunity to respond. Depending on the facts of the case and the jurisdiction in which it is filed, the case may proceed to a hearing or trial. In federal court, judicial proceedings include written pleadings, discovery, pretrial proceedings, and the trial. Oral arguments may also take place before the court makes its ruling. In some cases, the proceedings may be concluded with a settlement or plea agreement between the parties. In the United States, judicial proceedings are typically public. This means that anyone is allowed to observe the proceedings, although certain matters may be kept confidential or sealed. Additionally, the proceedings are usually recorded and transcribed so that they can be reviewed or appealed later. Finally, the proceedings are typically conducted in accordance with established rules of procedure and evidence, which are designed to ensure fairness and accuracy. Early precedent on full faith and credit clause. Article 4, Section 1. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. And the Congress may by general laws prescribe the manner in which such acts, records and proceedings shall be proved, and the effect thereof. The 1817 Supreme Court case Martin v. Hunter's lessee addressed the full faith and credit clause's scope. In this case, the court held that the states must give full faith and credit to the judicial proceedings of other states and must recognize the judgments of those states' courts. The court also held that the states are not required to give full faith and credit to the laws of other states. In the 1845 case of Foster v. Nielsen, the Supreme Court further clarified the scope of the full faith and credit clause. The court ruled that states must recognize other states' laws and judicial proceedings in this case. The court also held that the states are not required to enforce the laws of other states. The Supreme Court has continued to interpret and apply the full faith and credit clause in subsequent cases. These cases have established that the states must give full faith and credit to the public acts, records, and judicial proceedings of other states and must recognize the judgments of those states' courts. States must recognize and respect the laws of other states, but they are not required to enforce them. Current doctrine on full faith and credit clause. Article 4, Section 1. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. The full faith and credit clause requires states to recognize and uphold the legal rights and obligations of other states. This includes giving full faith and credit to court orders, judgments, and decrees from other states. This means that if a court in one state issues a valid order, then all other states must recognize and enforce it. This is important because it ensures that legal decisions made in one state are respected in other states, and that individuals cannot simply move to another state to avoid having their legal obligations enforced. The Supreme Court has also established that states cannot discriminate against the laws of other states. States cannot refuse to recognize or enforce another state's laws just because they disagree. This principle ensures that states respect each other's laws and don't impose their own. The Supreme Court also ruled that states must provide the same privileges and immunities to citizens of other states. States cannot deny citizens from other states the same legal rights and protections they provide to their own citizens. States must honor other states' legal rights and obligations under the full faith and credit clause. Must treat citizens of other states equally and not discriminate against their laws. This ensures that people from different states are not denied the same legal rights and protections. State public acts and records. State public acts and records are available in most states in their respective state legislatures. Each state's legislature website has public laws, regulations, and other documents. Some state records might also be available in libraries and other public archives. Additionally, state records may be available through the Freedom of Information Act, FOIA. Early Doctrine on State Law on Full Faith and Credit. Article 4, Section 1. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. The Congress may, by general laws, determine how such acts, records, and proceedings are proved and their effects. Early doctrine on state law on full faith and credit was that it applied only to judicial proceedings. If the laws of other states did not conflict with their own, the courts were expected to enforce them. This doctrine held that states should respect each other's sovereignty and let their courts decide on matters within their jurisdiction. This doctrine was established in the U.S. Supreme Court decision in the case of Hampton v. McConnell, 1829. Thanks for watching.